And I appreciate this letter, but it's all ridiculous when you look at your criminal history and the fact that you're on parole and you commit 2 more offenses and you're still using drugs and you haven't made, it's not like you're a young kid. You know what you need to do to get the help you need to get. And you've made a conscious decision not to do that. So this time and cause.
It's all ridiculous. That is what the judge said, out loud, on the record, to a man sitting in front of her with his family in the gallery, a mental health file on her desk, and a support letter submitted by his attorney specifically to soften what was coming. She did not say it quietly. She did not hedge it. She looked at the paperwork, looked at the criminal history sitting next to the paperwork, and said the word that no one in that room was expecting a judge to say. Ridiculous. And then she sentenced him to 20 years. But to understand why that word landed the way it did, why it was not cruel, why it was not unprofessional, why it was, in fact, the most precise legal and moral assessment anyone could have offered in that room on that day, you have to go back to the beginning. To a man named Floyd Torin, to a courtroom in Jefferson County, Texas.
Okay, you're Floyd Torin. And this is cause numbers 25 DCCR 0974 and 25 DCCR 1152. Mr. Torin was previously in court, entered pleas of guilty to attempt to commit theft of property. It was enhanced to a 2nd degree because of priors, and then evading arrest or detention with the vehicle, also enhanced to a 2nd degree. I've received the pre-sentence report, and the agreement was for a cap of 20 years. It looks like it probably could have been habitual, but you guys pled it to just.
And to a pattern of choices that stretched back further than most people's entire adult lives. Floyd Torin did not arrive at this sentencing hearing as a first-time offender navigating an unfamiliar system. He arrived as a man about to enter his 11th and 12th felony convictions. Let that number sit for a moment. 11 prior felonies before he walked into that room. The 2 charges before the court today, attempt to commit theft of property and evading arrest or detention with a vehicle, would become numbers 11 and 12 on a list that had been building since his juvenile years. Both charges had been enhanced to 2nd-degree felonies. Enhancement is a legal mechanism. It means that because of prior convictions on your record, a charge that might otherwise carry a lighter sentence is elevated to a more serious classification with a heavier sentencing range. The state had actually been prepared to pursue something even more severe. The prosecutor noted on the record that this case probably could have been filed as a habitual offender charge. Habitual offender status in Texas is exactly what it sounds like. A formal legal designation for someone whose pattern of reoffending is so established that the law treats it as a defining characteristic, not a situational lapse. The sentencing ranges under habitual status can be dramatically higher. The prosecution agreed to come off that designation as part of the plea arrangement, capping the potential sentence at 20 years.
It was for a cap of 20 years. It looks like it probably could have been habitual, but you guys pled it to just a straight 2nd degree with an open plea to the 2nd, correct?
Yes, ma'am.
And I've received the pre-sentence report as well as some documents that Mr. Radford has sent in with regard to Mr. Torin's mental health as well as some physical issues.
That concession was not nothing. That was the state already meeting him more than halfway. Floyd Torin had pleaded guilty. This was not a trial. There was no jury, no contested evidence, no cross-examination. A guilty plea means the defendant has acknowledged the conduct and waived the right to make the state prove its case. What remained was sentencing, the proceeding where the judge takes everything on the table, everything about who this person is and what they did, and decides what happens next. His defense attorney, Mr. Radford, stood up first. Now, every defense attorney in a sentencing hearing faces the same structural challenge. Their job is not to argue innocence. The guilty plea has already resolved that question. Their job is mitigation. That is the legal term for it, mitigation. And it means presenting anything and everything that might persuade the judge to land at the lower end of the available sentencing range rather than the higher end. Health problems, mental health history, family support, expressed remorse. Any factor that humanizes the person in front of the bench and makes the judge feel that leniency is not just sympathetic, but justified. Mr. Radford did his job. He noted his client's age-related health issues. He mentioned vision problems. He referenced treatment at Spinal Tap MHMR, a mental health and mental retardation authority in the Beaumont area of Texas, for documented mental health conditions. He pointed to the family members sitting in the gallery as evidence of a support system that could function as a stabilizing force going forward. He submitted documents. He submitted a support letter. He presented, in other words, every tool available to him.
Judge, Mr. Torin has an extensive criminal history. However, as he has gotten older, he has had some health issues. He has vision problems. He has been seen and treated at Spinal Tap MHMR for some mental health issues. He has a very supportive family who is here today, and I'd ask that the court take that into consideration in determining his sentence.
The prosecutor, Mr. Smith, did not dispute the health issues. He did not argue with the family. He made one argument, and he made it cleanly. Floyd Torin's criminal history, he said, going all the way back to his juvenile years, tells you more about who this person is and what they will do than anything else in this file. Probation had been tried. It had not been completed. Long prison sentences had been imposed. The only period during which Floyd Torin was not committing new crimes was the period during which he was physically incarcerated. The prosecutor's position was simple. The only thing that has ever worked is a wall between this man and the public. He asked for a sentence in the high range.
Mr. Smith?
Judge, his extensive criminal history going all the way back to his juvenile years tends to show more about what he is and what he does than anything else. He's been given probation. He wasn't able to complete that. He has been sentenced to multiple long sentences in prison, and that seems to be the only thing that has kept him from committing new crimes in society, was the fact that he was incarcerated. I don't feel like probation is appropriate. We would ask for, we have given him consideration by coming off of the habitual.
Then, the judge began asking questions. She turned to Floyd Torin directly and walked through the timeline. In 2019, he had received a 15-year sentence. She noted she did not have the exact release date in front of her. Torin supplied it himself.
Mr. Torin, in 2019, you received a 15-year sentence. So you were only I don't know how long it doesn't show me when you got out or how long you were in on that, but obviously. So you got out in 2023.
August 9th, 2023. He had gotten out in the summer of 2023. Less than 2 years later, he was standing in her courtroom on his 11th and 12th felony charges. 19 months of freedom.
And less than 2 years later, you've got 2 more felonies, which add up to your 11th and 12th felony offense. And I understand the issues with PCP.
That was the window. That was everything the system's investment in rehabilitation, in second chances, in the possibility of a different outcome had produced. 19 months. Here is where I want you to think about something. At what point does the gap between the system's good intentions and documented reality become a number too large to talk around? The mental health file was real. The health issues were real. The family support was real. None of that is in dispute. But the judge was also sitting with a substance abuse assessment in which Floyd Torin himself had told the evaluator that the only time he had ever been clean was when he was in custody, not in treatment, not in recovery, in custody. He had said it himself, out loud.
Try to get in TDC, out of TDC, to live your life outside of prison, and you've chosen not to do that. Your only time clean is when you're in custody. That's what you told the person doing that substance abuse assessment.
To the person whose job it was to write it down. And it had been written down. And it was on the judge's desk. Leave that in the comments, because I think reasonable people can disagree about where individual responsibility ends and systemic failure begins. And this case puts that line in an uncomfortable place. The judge acknowledged the family. She acknowledged the letter. And then she said the sentence that this entire proceeding had been quietly building toward. She appreciated the family being there. She appreciated the support. She appreciated the letter. But it was all ridiculous. Not the family, not the effort, the proposition. The implicit argument that a support letter and a mental health file constituted meaningful mitigation against 12 felony convictions, a parole violation, and a vehicle chase through Jefferson County that had nearly killed people at 2 separate intersections.
This evading was crazy. You could have killed people. You got used, I think it was twice you almost struck intersection of Interstate 10 and 7th Street, almost struck another vehicle. And then again at 7th Street and Dollinger, you almost struck another vehicle. You crashed through a fence. Then you continued to flee after you crashed through a fence and crashed again and finally came to arrest. It's not like you just kind of sort of evaded. Your behavior is.
She described the evading charge in specific terms. Twice, his vehicle nearly struck other cars at the intersection of Interstate 10 and 7th Street. Again, at 7th Street and Dollinger, he had crashed through a fence. He had continued fleeing after crashing through the fence. He had crashed again. He had finally been stopped. This was not, as she put it, someone who had kinda, sorta evaded. This was, in her documented assessment, a person whose behavior was a danger to everybody in Jefferson County.
Just a danger to everybody here in Jefferson County. So that being said, 25 DCCR 0794, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of an attempt to commit theft of property, find that prior conviction.
Stop here, because this is the midpoint of this story. And everything that comes next follows directly from one word she used that most people in that gallery probably walked right past. Conscious. She did not say Floyd Torin was incapable of getting help. She did not say the mental health issues were invented or irrelevant. She said he had had every opportunity as a grown man to get the help he needed, and he had made a conscious decision not to. That is a specific legal and moral framing. Conscious decision. It means the court is treating the choices as choices, not compulsions, not symptoms without agency. Choices made by a person who had been in and out of the system long enough to understand exactly what his options were. That framing matters because it is the foundation of what comes next. Sentencing in criminal law is built on several competing philosophies that courts weigh differently depending on the case in front of them. Rehabilitation says the purpose of punishment is to change behavior. Deterrence says the purpose is to discourage future conduct, both by this individual and by anyone watching. Incapacitation says the purpose is simply to prevent the person from causing more harm by removing them from society. And retribution says the punishment should be proportionate to the harm caused, as a matter of justice rather than consequence. Most sentencing decisions blend all four. What was notable here was that the judge's language leaned almost entirely on two of them, incapacitation and accountability. She did not invoke the possibility of rehabilitation, not once. The substance abuse assessment had removed that option from the conversation when it recorded his own words. She spoke about public danger. She spoke about conscious choice. She spoke about what he had done and what he had refused to do. The sentence she was about to impose was not an expression of hope. It was an expression of record. 20 years. In cause number 25 DCCR 0794, the attempt to commit theft, enhanced to a second degree, 20 years in the Institutional Division of the Texas Department of Corrections. In cause number 25 DCCR 1152, evading arrest or detention with a vehicle, enhanced to a second degree, 20 years in the Institutional Division of the Texas Department of Corrections. Concurrent. That is the term she used when she handed him the paperwork. Concurrent means both sentences run at the same time, not one after the other. If the sentences had been stacked, the legal term is consecutive, he would have been facing 40 years. Concurrent meant the sentences ran on the same clock, 20 years, starting from credit for any time already served.
Find also sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 20 years in the Institutional Division of the Texas Department of Correction. You will receive credit on each of these sentences for any time that you've been in custody that the law gives you the right to receive.
She handed him the trial court certification. She noted he had waived his right to appeal, a standard component of a negotiated plea agreement, meaning he had agreed as part of the deal not to challenge the conviction after the fact. She handed him a written admonishment regarding his ineligibility to possess a firearm or ammunition under Texas law as a result of these judgments. She told him if he had questions about what that meant or how long it lasted, he could speak with his attorney. And then he went back with the bailiff. The proceeding was over in under 7 minutes, from the first word to the last. Here is what this case teaches you, and I want you to hold on to this if you ever find yourself sitting across from a lawyer in a sentencing context, as a defendant, as a family member, as someone trying to understand what is happening and why. Mitigation is real. It is a legitimate and important part of the sentencing process. Mental health history matters. Family support matters. Health issues matter. A good defense attorney raises all of it, and raising it is the right thing to do. But mitigation does not exist in a vacuum. It exists in conversation with the documented record sitting on the other side of the scale. And when that record is 12 felony convictions, a self-reported substance abuse assessment, a parole violation, and a car chase that nearly killed civilians, the mitigation has to do more than exist. It has to actually move the scale.
The judge was not dismissing the effort. She was doing the math out loud. There is a version of this story where the family letter changes something, where the mental health documentation opens a different door, where the judge looks at the same file and finds a reason to land lower. That version requires a different record underneath the mitigation. It requires a history that suggests the intervention might actually intervene. It requires the substance abuse assessment to tell a different story than the one Floyd Torin told the evaluator himself. Conscious decision. That phrase does not appear in the Texas Penal Code. It is not a legal term of art. It is a judge speaking plainly about what she saw in front of her. A man who had been given, by her count, every available opportunity to choose a different path, and who had, by the only available evidence, chosen not to. The support letter was not ridiculous because the family was wrong to write it. It was ridiculous because the record made the argument it was making impossible to sustain. And a judge who says that out loud, on the record, is not being cruel. She is being honest. And in a room full of paperwork, in a system that can bury hard truths under procedure and deference and careful language, honesty delivered plainly is sometimes the most powerful thing a judge can offer. Not to the defendant, to everyone else in the room who needed to hear exactly what the record showed, stated in terms that no one could walk away from without understanding completely. 20 years. Concurrent. Effective immediately. The gavel did not need to fall dramatically. The math had already landed.